Thank you.
So the trustee must fulfill some duties. And some of the important duties of a trustee are these: the duty of care in dealing with the assets that are vested in them. This is very important because if you do remember, when I was defining a trust, I said that the trustee is the legal owner of the assets. So anytime, any day, the trustee is the legal owner. But the trustee is constrained in that they can only use the benefits of that particular asset for someone else. He, the trustee, he or she cannot enjoy the benefit. So in order to ensure that the trustee is doing the right thing, the law imposes a duty of care on the trustee when dealing with trust assets. And this duty requires the trustee to act in good faith. And the trustee must also act in accordance with the terms of the trust as outlined in the trust deed or agreement or any kind of instrument created for that purpose. And this duty of care also requires the trustee to act in the best interest of the beneficiaries. And of course, to act in accordance with the law in our border. And the legislation in question is called the Trustee Act, our border. So another duty of the trustee is to avoid a conflict of interest. I explained to you why a lawyer who has worked in creating something might say, no, I'm not going to be the trustee here. And the conflict of interest thing is important so as to ensure that the trustee is actually acting in the interest of the beneficiaries and that the trustee is not allowing their personal interest to interfere with the work that they are doing. And that requires the trustee also to avoid taking steps that may overtly or covertly benefit them. So, except if those steps are allowed by law or expressly permitted by the trust document. But most times the law doesn't allow a trustee to benefit from the way the trustee handles the assets, or the trust agreement most times doesn't also allow the trustee to benefit personally, but the trustee may be compensated. We'll get to that. And the trustee will also be required to provide reports to qualified beneficiaries in accordance with the law in Alberta, the Trustee Act. And of course, provide the beneficiary with information or an account if the beneficiary requests to have that information or account. So upon request, you provide what the beneficiary is asking that you provide. Because if you do remember, you are holding it in trust for them. They are the beneficial owners. So the next one is the powers of the trustee. So as the legal owner of the assets that are vested in them, a trustee has all the powers and the capacity that an individual of full legal capacity will have if the assets were to be vested in that individual for the individual's own use. For example, if I am a trustee and you passed on your property to me as your trustee, I have the power to handle that property as I could have handled my own property because I have the capacity to do it if it were to be my property. So I could sell the property if I wanted to. I could lease it out if I wanted to. The only constraints to this power will be the act which requires that whatever I do as a trustee, I must do that in accordance with the Act, and bearing in mind that it should be done in good faith, and that I will have to act in the best interest of the beneficiaries. So because of that, I have to be mindful of what I do, but I have the power to do it. Anything that I could do on my own. So I can sell the property, lease the property, I can borrow money for the purpose of carrying out the trust. I can create a security interest in the trust property. By the way, the security interest means that I may mortgage the trust property to get some money to carry out the intention of the trust. And the court may also confer additional powers on the trustee, but that will depend on the circumstances of the trust and the needs and conditions of the beneficiaries. So the next one that I want to talk to you about is the compensation. So, but before I talk about the compensation, I gotta tell you that duties and powers of the trustee apply to both the professional trustees and non-professional trustees. They apply to the institutional trustees. When I say institutional trustees, I mean the trust companies, and the non-institutional, which can be a regular individual in the society, or a lawyer, or an accountant. So you cannot say, oh, I don't have to do this because I'm an institutional trustee, or I don't have to do this because I'm just a regular Joe. I don't have to deal with all this court requirements and the legal requirements. No, you have to. So for the compensation of trustees, the law says that the trustee may be compensated, is entitled to their fair and reasonable compensation. So they may be compensated out of the trust. So if the trustee has professional skills and has used those skills to render services above the services that are generally associated with the office of a trustee, that professional is entitled to charge fees at reasonable rates for those that are reasonably necessary, if those services are reasonably necessary for carrying out the trust. For example, you appoint an accountant as a trustee, and the accountant does, and a beneficiary asks for an account, statement of account, and an accountant puts up a statement of account and sends it to the beneficiary. The accountant is entitled to charge his or her regular fee on that, the service that they have provided. Charge it to the trust. The same thing will happen if you do appoint a lawyer as your trustee. But whoever you appoint, that person is entitled to a fair and reasonable compensation. And the fair and reasonable compensation will usually depend on the value of the trust. You don't, if the trust is worth 200,000, you don't draw a compensation of 20,000 a year from that trust. That is not fair and that is not reasonable. That is just an example. However, if the set law of the trust says you can do that, it's going to be hard for any person to beat that. But no, I don't think any set law can agree that you can draw such an unreasonable amount from the trust. So, is it a good idea to create a family trust? The answer is that it all depends on you. There is no right or wrong answer to the question. It depends on your family needs or size or the complexity of your family assets and what you actually want to achieve. However, if there are minors to be provided for, it makes sense to create a trust for them. especially in the will of their guardians, or their parents. Or you can also, it's also a good idea to create a trust to make provision for special needs family members. With that, you'll be rest assured that they will be taken care of. But what happens is, it's usually the last of the parents that may require to create this trust, because the first, for partners, the first person might say in the will, if anything happens to me, everything that I own goes into my partner's hands. And that partner will take care of the children. So there is no problem there. But when that second partner passes on, there might be the issue of what happens. So the first person can say, if I pass on, it goes to this person, and this person can hold all these things in trust for the children. And if this person passes on, this is what happens at that point. So how do you, oh, okay, thank you for this one. Is it a good idea to create a family trust? The part two of it is that there might be tax benefits, but the tax benefits are usually realized if there is a huge value, if the assets in question are of a huge value. That's when you can see a tangible tax benefit. But I usually tell people, speak to an accountant about what the tax benefits might be in your situation. It's always important to speak to an accountant, because if you don't have a lot in your trust, in your portfolio, and you're creating a trust, you might end up spending so much money and only to realize that you don't have so much to gain out of it. So how do you set up a trust? So the how in this situation would depend on you, if you're the one who is thinking of setting up a trust. But there are important steps to follow, and those steps are really important. The first one is that you have to determine the objectives that you want to achieve with the trust. It is very important for you to have very clear objectives. For example, if you're setting up a trust because you want that trust to be part of your estate planning, you need to be clear on that. Or if you want it for the purpose of protecting your assets, or you want it for the purpose of gifting to a charity of your choice, or to provide for minors, special needs, family members, or any other reason that might be important to you. When you have decided on the objectives, when you're clear on your objectives, you have to think about who shall be the trustee. When I was talking about the roles of a trustee, the duties and the powers, I made it clear that this is something that requires a lot. It's a big ask. You have to weigh the people you want as the trustee. Talk to the person. And it's not something that you're just going to do on a whim because, oh, he's nice, I think he can do it. Only for you to realize, or you might not even realize it because you might have gone by then, that this person cannot do it. And your intentions might not be realized. So after you have decided on who you want to have as a trustee, you might want to think about the amount of funds or assets that you want to put in the trust. And this is important because the trust anticipates that there must be something in it. And this can be cash, can be a life insurance policy. It can be a real estate that you want to go into trust for management purposes. And it can be investments, bonds, stocks, mutual funds, segregated funds, any of those investments. It can also be your jewelry, your artwork, or other valuables. which you believe will be worth it to have in trust. So when you have done that,
Barrister,
go
so
ahead.
before you move on from this one,
Mhm.
thank you so much. This is actually quite eye-opening for me. There's a few things quite a lot of things I didn't know before this hour. So it's still ringing in my head about the individual trustees. So let's say I have a client, they have a life insurance policy, they have minor children, and is a single mom. Okay, so meaning that maybe the father is not in the picture and the mom passes away, and then they name a trustee. So the money will be paid, the life insurance payouts, to say $500,000, will be paid out to the trustee in cash. Now, is there any protection? Now, because it's a trust, because it's a trust relationship, is there any law that protects those minors in the event that the individual trustee misuses the money?
Yes, so when a trustee gets the funds, if you remember, they talk about the duties. One of the fundamental duties is the duty of care, because
Yes.
the relationship between a trustee and the beneficiary is the type of relationship called a fiduciary relationship.
Yes.
And when you have a fiduciary relationship, there is an obligation on you as a trustee to watch out for the beneficiaries. You get the money, you have to use it in the way that a reasonable and prudent investor can use it. So that is why it is important to choose the right person for that role. Because if the children are minor, if they are minors and then they don't know what is happening,
Exactly.
the money might have gone by the time the children question anything. Somebody, for example, a public trustee's office might intervene if they know that something wrong is happening.
But they'll have to know.
Yes, that somebody might also intervene, and a family member might also intervene by letting the court know that this is happening. But if nobody intervenes, the trustee gets it. By the time everybody knows, there might be nothing. The worst that could happen, or the best that could happen for the minors, will be for the trustee to be charged and all of that. But the minors might not benefit anything from the criminal charge or the criminal conviction. So that's why it's important to choose the right person for that. But then if you don't have the right person that you can choose and go with the trust companies, that will be the protection that you are looking for.
Exactly. So then we have better protection if we go to a law office or a trust company.
If you go with a professional or an institution, you are better off.
Thank you so much for that.